Hi everybody. Today I'm going to be shortly briefing the case of New York Times versus Sullivan. So here are some of the facts of the case before we delve into it. The original issue arose in 1960 when the New York Times was paid to print an ad in its paper in support of Dr. Martin Luther King and his efforts in the civil rights movement. And one of those areas targeted in the ad that the ad was critical of was Montgomery, Alabama. It didn't target any public officials in particular, it just targeted certain areas of the country in the South. One figure in particular did not take a liking to it, and his name was L.B. Sullivan, who was a police commissioner, or one of the police commissioners in Montgomery, Alabama at the time in 1960. And he sued, first going to the Alabama Circuit Court for libelous per se against the New York Times, stating that the information printed was libel, mostly because some of the information was not factual. Mostly things like the amount of times that Martin Luther King had been arrested was wrong, or small things like that. And it also said that people in the South, especially public officials in the South, were violators of the Constitution. And he saw that information, even though he was not directly targeted as libelous, and filed a suit against the New York Times for $500,000 in compensation. What happened was the Circuit Court of Alabama stated judgment for the plaintiff and stated that the information was libelous, and granted Sullivan $500,000, the amount that he had sued for in the first place. And the case then went to the Alabama Supreme Court in 1962, and the judgment of the Circuit Court was upheld. So the New York Times appealed that case, and it went to the Supreme Court. The New York Times appealed under the violation of what they believe to be two of their rights, first being the First Amendment, the freedom of speech, and the 14th Amendment, which is a violation of due process laws that everybody in America, including the New York Times, should be afforded. So under the case, the issues were the rulings of the Alabama Circuit Court and the Alabama Supreme Court a violation of the Times' First and 14th Amendment rights, even if some of the printed information was false, and under the proper safeguards of freedom of speech and the 14th Amendment, were the safeguards of the Constitution, under the safeguards of the Constitution, was the evidence presented sufficient enough to claim libel? The evidence presented by Sullivan, was that enough to claim libel? The holdings for this case, basically what was kind of concluded were the rulings against the Times were a violation of their First and 14th Amendment rights, being that the Times was able to print that information, and under the due process of Alabama's laws, that was deemed unconstitutional based off of the due process of the United States laws granted to people in the United States under the Constitution. And the evidence provided in the case was not sufficient. And the reasoning for that was, for number one, the Times printed the ad with belief that everything was factual. So they did not print it with knowledge or reckless abandon, just like trying to get it out there. They thought that they were printing a factual ad, and the Times is not owned by the state, and it's its own it's its own public paper, so it's not held by some of the rules of maybe a state official or a state organization. And the ad was bought by a third party. So because the Times is a private party not of the state, and because the ad was purchased by the outside third party, the Times was protected by the First and 14th Amendments, and the evidence provided to support the Times does not hold up, because the ad purchased by the outside party was entirely deemed commercial advertising by the Supreme Court. And to avoid placing a limit on the freedom of expression in media outlets, if you have maybe an op-ed in the paper, or if you have an ad, the Supreme Court did not want to claim the evidence provided as sufficient to limit things like that in the future, which is why papers to this day still can print op-eds and put ads in the paper without it being libel. The rule of the law, how it's being enforced, what the court enforced. Finally, the New York Times versus Sullivan established that newspapers, other media outlets could not be held liable for what was considered defamatory information by public figures and officials if the statement isn't made with actual malice, which is the important thing in this case. Actual malice is the knowledge of making a false statement or disregard of the truth. And unless information is proven to be published with that actual malice, then the speech is prohibited. The speech is protected under the Constitution. Thank you for listening. I hope that this video helps you guys a little bit with your understanding of the New York Times versus Sullivan. And good luck reading through the brief and watching the video. Thanks.